right, so let me tell you what we're going to discuss today. We have a lot to get through. So we better get started in earnest. We'll talk about the skilled worker salary increases. That's really big news. Talk about changes to sponsor duties and processes. There's a lot to say there as well. We'll look in particular at the immigration salary list and how that affects the salary increases. We are going to devote some time to health and care visas specifically. We'll talk about the phase out of biometric resident permit cards that is going to take place over the course of this year, or is already taking place. We'll discuss changes to right to work, the checks and penalties. We'll discuss changes to the business visitor rules. And I'll also run through some salary changes to other UK work and business visa routes. And then I want to just spend some time explaining what some of those other options are in case they're useful to you as an alternative to the skilled worker route. And then finally, we'll discuss electronic travel authorizations. Query about that. All right, let's talk about the skilled worker salary increases. So the basic summary is that the general salary threshold for the skilled worker route has been raised to £38,700. That's from 26,200, and that happened on the 4th of April. Okay. People who use the skilled worker route will know that there's a general salary threshold that has to be met, or you have to meet the going rate, which is specific to the occupation. And every role in the UK is purported to fall under one standard occupational classification code or another. And the salary requirement has to be the higher of the general salary threshold, the going rate, or the minimum hourly rate that's applicable. So the general salary threshold has gone up, and the going rates have also generally gone up because they're now based on standard occupational classification, or SOC 2020 data, rather than SOC 2010 data. Additionally, the going rates have increased from using the 25th percentile of jobs in a particular SOC code to determine the going rate, to using the 50th percentile, or the median, to determine the going rate. Now, percentile means that so 25th percentile, for example, means that 25% of salaries for jobs falling under that SOC code would be lower than the going rate set at 25th percentile, and 75% would be higher. So the new SOC 2020 data and the new going rates for new skilled worker applications relies on 50th percentile of SOC 2020 data. So that means that 50% of roles falling under that standard occupational classification code would have a lower salary, and 50% would have higher. There is an exception for health and care worker occupations. We'll discuss that in a bit more detail in a few minutes. So consider when you're just trying to determine the relevant salary requirement for a role, consider the salary points option that applies and the going rate. So let's talk about these in a bit more detail, the salary requirements in a bit more detail. So where the certificate of sponsorship is assigned 4th of April or later, the minimum salary is going to be the highest of 38,700 per year, the going rate, or that hourly rate. And for certificates of sponsorship from 4th of April or later, that hourly rate is £15.88 per hour. For skilled worker certificates of sponsorship assigned, for skilled workers who were already in the skilled worker route before 4th of April, the minimum salary is going to be 29,000 per year, £11.90 per hour, or the going rate for the roles SOC code. So there's a transitional arrangement where if you're already in the route, then you can rely on the 25th percentile. So 29,000 per year is a 25th percentile for all of the eligible SOC codes. So that's gone up from the general salary threshold before 4th of April to 29,000 because of inflation. Now there are discounts to the general salary threshold set out here and the going rates depending on circumstances. We'll look at those in just a minute. And different salary requirements apply to health and care workers. So there are now salary points options A through K. Okay, so you remember I said, look at the salary points option, consider the applicable salary points option, and then consider the going rate. Now there are now options A through K, but I don't want you to feel too overwhelmed by that because you'll see that you'll be able to discount several of the options in bulk right away, okay? So for options A through E, okay, those are going to apply where the certificate of sponsorship is assigned on or after 4th of April, 2024. And the individual did not have skilled worker permission previously, does not have skilled worker permission, okay? So option A is the default option, let's say. It's the general salary threshold without any discounts, and it's the full going rate for the role. Okay, so it's at least 38,700 or the full going rate for the role. And you'll find the going rates listed in the immigration rules. All right. Option B is if they have a relevant PhD, then the general salary threshold is discounted and the going rate is discounted. If they have a relevant STEM PhD, that's option C. Those are further discounted. Option D relates to the immigration salary list. So this was previously the shortage occupation list. There is a 20% discount on the general salary threshold, but there is no discount on the going rate as there used to be for the shortage occupation list. Okay, and then option E is for new entrants. So somebody who's less than 26 years old, a graduate, visa holder, or a student who's switching into skilled worker. So there's a discounted general salary threshold and a discounted going rate for those. But all of these options, option A through E, is for newcomers to the skilled worker route. Okay, so these are for permissions on or after 4th of April, 2024, skilled worker permissions on or after April 2024. So if you're dealing with somebody who already has skilled worker permission or their certificate of sponsorship was assigned before 4th of April, 2024, then none of these apply. I should say, if you're in a situation where you've assigned someone's certificate of sponsorship before 4th of April, 2024, and you're now going to make their application for permission, then actually none of these options that will be reflected on the slides today would be relevant. Those applications will be decided in line with the rules in effect before 4th of April, 2024. So you have to look at the rules archive actually for those for information on how those applications will be assessed, because they're going to be assessed under the previous rules. So this is just where a cause is assigned on or after 4th of April and the person did not have skilled worker permission before then. So what if the person already did have skilled worker permission or they or they're in a health and care role. Well, that's when you look at options F through K, okay? So these are only for people who were granted permission before 4th of April, 2024, and they're continuing in the same occupation, or the role qualifies as what's been designated as a health and care ASH salary job. And we've listed those jobs here. You'll see they'll include the very popular SOC codes 6135 and 6136 for care workers and senior care workers. But I'm just going to go back to this slide. So again, these options are available for people who had permission before 4th of April or were granted permission in line with a certificate of sponsorship assigned before 4th of April. Okay, so basically they have permission in line with the rules in place before 4th of April. So they're able to take advantage of these options. Option F is going to be the default option for this tranche of salary options, where again, the salary is at least the going rate and they're paying the full £29,000 general salary threshold for these types of applications. And then you have the same breakdown as you did on the previous slide. So you've got options with discounts for PhDs, relevant people with relevant PhDs, people with relevant STEM PhDs, the immigration salary list roles, and people who are new entrants. So they're all going to benefit from, options G through J benefit from discounted general salary thresholds, and other than option I, which relates to the immigration salary list, you're also going to benefit from discounted going rates for options G through J. Okay, so you can think of them as like special circumstances options. Option K is for health and education occupations where the going rate is based on national pay scales. So that would include certain therapists, for example. So that's the main breakdown of the salary changes. And I hope you'll see that it's not as complex as you first would have thought. Okay, so think about what type of permission the worker has. If they have permission that was granted in line with the rules in place before 4th of April 2024, then they might be able to take advantage of F through J. If they have, if they're only applying in line with a certificate of sponsorship assigned after 4th of April 2024, and they don't have skilled worker permission, then you'd be looking at these options A through E, okay? And again, we're going to look at the immigration salary list and health and care visas in a bit more detail. This slide just demonstrates some examples of the going rates. So we have the new going rates in the rightmost column, and you'll see for some roles it's quite significant. So for CEOs, which now fall under the SOC code 1111, the going rate that would be required has gone up from 54,700 to 84,100 annual salary. And we've just included some other common standard occupational classification codes that we use a lot when we're working with our clients, in case they're relevant for you, just to highlight some of these roles for you. Right, so let's talk about changes to sponsor duties and processes. Do let me know if you have any questions about the salary changes. Happy to answer those, but otherwise we'll go on to changes to sponsor duties and processes. I see somebody has asked about a change in the SOC codes, and that's correct. The SOC codes have changed between the standard occupational classification 2010 data and the 2020 data. So you'll have to match up the SOC codes. Again, the way they match up is listed in the rules. Get in touch if you need specific advice. So let's talk about the changes to sponsor duties and processes. All right, I want to talk about defined cause allocation applications. And just to go back to basics for a minute, I'm going to give you a pop quiz. Oh, thank you, Carolina. I'm glad the changes are clearer now. Thank you for your comment in the Q&A. Right, let me give you this quiz. Sorry, 1 second. Oh, have you lost the presentation now? Right. Having trouble pulling up the poll. So I think what I will do, apologies, is just take a show of hands. So who thinks you use a defined cause when you are trying to sponsor somebody for a skilled worker visa, and they're going to be switching from another visa category from within the UK? Raise your hands. Okay, we've got 3 people so far. Who thinks you use a defined certificate of sponsorship when you are wanting to sponsor a senior or specialist worker, so previously known as intra-company transfer, to come to the UK from overseas? Okay, and who thinks you use a defined certificate of sponsorship when you are trying to support a non-UK national to apply for the skilled worker visa from overseas? Okay, so this was perhaps not the most scientific way to run the poll, but it does seem that most of the people answered correctly. You use a defined certificate of sponsorship when you're trying to support somebody making a skilled worker visa application from overseas, okay? In all other cases, you'd be using an undefined certificate of sponsorship. So there are new information requirements that apply when you are making an application for an allocation of defined certificates of sponsorship or defined cause. So first of all, you now have to state which points option you're relying on, okay? And if you've identified a worker, you have to explain how they meet the points option. If the worker is a new entrant, you have to give some of their personal details. So their name, their date of birth, and their nationality. As previously, you have to state the total weekly working hours, but now there is a specific field available on the DCAUSE application form that you can use for that. You no longer have to shove it into the summary job description. Where the work is going to be on a client contract, you have to state the client's details and the details of the contract. Work on a client contract is an area of skilled worker sponsorship that the Home Office has been quite lax about historically. But this change and a number of other a few other activities that have happened indicate that they're going to be assessing this client contract, the client contract arrangements much more closely going forward for compliance. And there's some new wording in the guidance that was published on the 4th of April in line with the new rules that is a bit concerning, which is that if UK Visas and Immigration, rejects an application for a defined cause allocation, or a sponsor persistently submits defined cause allocation applications which are rejected, UKVI may take compliance action against the sponsor. So this could come up quite often. You know, I'm often pulled aside at cocktail parties with somebody, you know, nearly in tears saying they got a refusal. And when I dig into it a bit, it turns out, oh, they were just refused a defined cause allocation application. And historically, I haven't worried about that very much. It's not a visa refusal or anything, you just apply again. But if it's now going to lead to compliance action, if you're being refused, then it is more serious. And those do have to be prepared very, very carefully going forward. Let me know if you have any questions about defined cause allocation applications. Otherwise, I'm going to talk a bit more now about compliance action and compliance checks generally. So things that might trigger a compliance check are reasonable suspicion that a sponsor has breached their duties. That's not really new. A poor previous record of compliance with UKVI, but also now poor previous record of compliance with other government departments. And in particular, the new guidance highlights compliance with UK or UN imposed sanctions. So sponsor can't be subject to sanctions and must be paying their VAT as appropriate and any other duty penalties as appropriate. They've also now added that revocation of a sponsor license is mandatory for a caseworker if a sponsor never held a registration or accreditation that they require. So this could be applied in terms of CQC requirements potentially, or, you know, for law firms, you know, SRA registration, etc. That's the type of registration I think that would be relevant there. So other changes relate to reporting duties, and in particular in relation to work locations. So you do have to report changes to a worker's main office location. And if they're starting to work at new client sites, that has to be reported. Now, a couple of years ago, or maybe it was just last year, the Home Office changed the guidance to state that employers had to report hybrid working. Then they almost immediately made noises about deleting those new provisions, and now they have. So you're no longer required to report where a worker moves to a hybrid working pattern, which is if they're working regularly from home and the office. In terms of remote working, you have to report if there's little or no requirement for a worker to attend the office or to attend a client site. And if you do have a worker in that situation, the Home Office is going to query why they need to be sponsored. In the UK, for example, why can't they work from their country of origin. So be aware of that. Right, any questions? Let me see, there's a question. I want to extend a worker's visa, but their occupation code is not in the SOC 2020 list. There's a different code for their current role. The worker's job title and job description won't change when we extend their visa. So in this case, which cause category should be used? Extension or change of employment? Interesting. So off the top of my head, if you've matched up the SOC 2020 and SOC 2010 codes, then it would be an extension. But if you'd like advice, do get in touch and I can assess the circumstances properly. Okay. All right, some good news, some nice, easy news, make it easier on everybody. Sponsor licenses are now valid indefinitely. They're never going to expire, okay? That's the Home Office's intention. To facilitate this, in the meantime, they don't have the tech to indicate, to reflect that there's no end date, validity end date for a sponsor license. So in the meantime, the Home Office fix is to automatically extend licenses by 10 years. So if your license was due to expire on or after 6th of April, then it should have been automatically extended by 10 years. And if you receive any notifications to renew your license going forward, those can be ignored. If you did apply to renew, then and your license wasn't due to expire until after 6th of April, then that application would be canceled and your renewal fee would be refunded. Yay! All right, I am going to pass over to my colleague to discuss the immigration salary list in more depth.
Thank you, Summer, for such detailed breakdown on the salary increase and sponsor duties. Okay, so let's break down the immigration salary list. The Home Office recently published a new immigration salary list, which has replaced the previous shortage occupation list. The immigration salary list is based on SOC 2020 data. And this new list has reduced from 51 jobs to 23 jobs. 20 of the jobs are available across the UK, and 3 of the jobs are available in Scotland only. So before the immigration salary list was published, there was shortage occupation list, as I mentioned earlier. And the shortage occupation list was based on the SOC 2010 data, and there was 20% discount on the going rates for roles that were on the shortage occupation list. But this has been abolished now. However, the immigration salary list also contains occupations where reduced salary threshold applies. So we have good news. The salary threshold for occupations on the immigration salary list is now 30,960 or going rate, whichever is higher. So if, let's say, a role on the immigration salary list has a higher going rate than 30,960, then the salary threshold would be the going rate. Please note that this is a lower general salary threshold than the default £38,700 because there's still a reduction in the general salary threshold on this immigration salary list. Let's look at some examples of subcodes on the immigration salary list. As I mentioned earlier, we can see that some going rates for some subcodes are higher. When we look at 3411 artists, the going rate is 32,900, and 3416 arts officers, producers, and directors, the going rate is 37,500. So in this case, if a role falls under, let's say 3411 or 3416, it means that the salary threshold would be the going rates and not the 30,960. And please also do not forget that these subcodes are based on SOC 2020 data. Also, eligibility is restricted to some subcategories. For example, when we look at 5319, construction and building trades, not elsewhere classified, we can see that it is restricted to only retrofitters. Okay, so if you've got any question about the immigration salary list, you can let us know. Although the immigration salary list did replace the shortage occupation list, we should also note that there are some subcodes that were on the previous shortage occupation list that are no longer on the immigration salary list. And examples are two subcodes that I will go into detail soon. Yeah, so examples are 2135 and 2136 subcodes that were based on the SOC 2010 data. So I would want to base on these two subcodes because they are quite popular in our practice and most of our clients use them. So for 2135, which is based on the SOC 2010 data, the equivalent of it is 2133 in the SOC 2020 data. And for 2136, its equivalent is 2134 in the SOC 2020 data. So when we look at the table, we can see that there are different salary options that apply to workers with skilled worker permission based on costs that were assigned before 4th of April 2024, and different salary options that also apply to workers with skilled worker permission based on courses that were assigned after 4th April 2024. Let's look at some examples. So when we look at SOC 2133, IT business analysts, architects, and system designer roles, for courses that were assigned before 4th April 2024, you can see that the salary thresholds that would apply are option F, which is 39,300, through to option J, which is 27,510. And then for the same subcode, if let's say courses were assigned, where skilled worker permission was based on courses that were assigned on or after 4th April 2024, the salary thresholds that would apply are option A, which is 51,700, through option E, which is 36,190. And the same apply to 2134 subcode program and software development roles. For, as I said earlier, for skilled worker permissions based on course that were assigned before 4th April, option F to J would apply. And then skilled worker permissions based on courses assigned on or after 4th April, option A to E would apply. And one thing we should also note is that roles under these two subcodes are no longer on the immigration salary list. However, the equivalent 2010 subcodes were previously on the shortage occupation list, but they are no longer on the immigration salary list.
Yeah, that's important to know. Thanks, Anna. So I figured out how to use the polls. I see if we have a question about a particular role and which salary would apply for a particular role. We're not going to have time to assess those on the fly and answer those, but we do have a scenario prepared to help you understand. So I'll launch that question now. It is this one. Okay, so Anna, do you want to read it out?
Yes, sure. So we've got Amma, who is a skilled worker, and her permission was granted based on a course assigned on 3rd October 2023. The SOC 2010 code on Amma's course was 2135. Amma has received a job and sponsorship offer from Changes Immigration, and her new role starts on 1st May 2024. Amma's proposed role at Changes Immigration is the same role she's performing for a current sponsor. So based on the information we've provided so far, which salary options will Changes Immigration have to rely on when assigning her new course? We've got option A, which is salary equals or exceeds both 38,700 per year and the going rate for the SOC 2020 occupation code. We've got option D, where the role is on the immigration salary list and salary equals or exceeds both 30,960 per year and the going rate for SOC 2020 occupation code. Option F is where the salary equals or exceeds both 29,000 per year and the going rate for the SOC 2020 occupation code. And finally, option I, where the role is on the immigration salary list and the salary equals or exceeds both 23,200 per year and the going rate for SOC 2020 occupation code. So let's see how we go about this.
You should be able to select the relevant answer. And just to help you along, remember the strategy that I suggested. First of all, decide whether you'll be able to use the salary points options for the transitional, under the transitional provisions. So allowing people who are already sponsored as skilled workers to take advantage of a general salary threshold and going rates at the 25th percentile as under the previous rules, or whether it's going to fall under the new salary points option. So first decide that, right? Based on when she was first granted skilled worker permission. If she was granted skilled worker permission under the previous rules, then you can use options F through J. If not, then you have to use options A through E. Okay, and then you can see, and you can decide further based on whether the role is on the immigration salary list or not. So is the role that was 2135 under the previous SOC code now 2133 under SOC 2020, is that on the immigration salary list? All right, so the majority of people answered correctly. Sorry, it seems like there's still answers coming in. I didn't realize. So the correct answer is points option F, okay? And just to talk you through that, or Anna, do you want to talk them through it?
Yeah. So can we bring the poll question back on the screen?
Oh, you can't see it?
No.
I don't know how to make you be able to see it. Sorry.
Oh,
Shall,
that's,
shall I?
yes, please.
I do hope I do hope that delegates can see the question. But basically, the answer is points option F because Amma already had skilled worker permission under the rules in place before 4th of April 2024. So she's able to use options options F through J. And then the two options available in this poll within those options F through J are F and I. So F is where the general salary threshold and the full going rate apply. And I is if the role is on the immigration salary list, which this role no longer is. So we can't take advantage of that option. So it is F. So I hope that's clear. I'm going to share the results. Can you see it now? Yeah, okay. Sorry about my, I'm not great at the polls. So somebody says they're getting a little confused. In general, the Home Office mentions you have to pay whichever salary is the higher between the general salary threshold, the going rate, and the hourly rate. For instance, it says the higher of the sought going rate or 38,700. Does this mean that every job has to be paid 38,700, or you can use the sought going rate even if it's lower? You cannot use the sought going rate even if it's lower. In that scenario, you have to pay the higher of the sought going rate or 38,700. So that means if the sought going rate is higher than 38,700, then you have to pay the sought going rate. So I hope that's clear. It's a good question. All right, I'm going to stop sharing this poll. Oh, I'm going to just get rid of this poll. Let's move on. Thank you so much, Anna. That was fantastic. All right. Nadia, would you like to talk us through the health and care visas?
Sure. Thank you. Thank you both. We are now moving on to health and care worker visa section. And if I could have the next slide. Perfect. Thank you. So unfortunately, health and care worker salary threshold has also increased. It is now 29,000 for occupations that are not on a national pay scale. So for instance, professions such as public health managers or healthcare practice managers are now required to be paid the minimum salary threshold of 29,000. This is also classified as option F. The next option K concerns the jobs on national pay scale for which the minimum salary paid is 23,200 or the full going rate. So some examples of the jobs on national pay scale are physiotherapists, occupational therapists, psychologists, and registered nurses. Immigration salary list has also reduced the jobs that were previously available under the health and care worker route to only 4 professions. You can see them on the screen. It's laboratory technicians, strictly those professions that require at least 3-year experience, pharmaceutical technicians, and of course, care workers and senior care workers. So for these 4 professions in this immigration salary list, the minimum salary is 23,200, except for the pharmaceutical technicians, for which the minimum salary is 23,400. Yes, thanks. So specific restrictions have been imposed on sponsors who are employing care workers or senior care workers. So due to the changes that happened on the 11th of March 2024, those sponsors who are wishing to employ new workers in these occupations, they must be registered with the Care Quality Commission or the CQC. And in addition to being registered, they must also carry out activities regulated by the CQC, and they must not be dormant on the register. However, the good news is that for those employers who have been employing workers under these routes and they continue to sponsor them, there is no requirement of the registration with the CQC, and their employees can extend their visas provided that they continue to be employed by the same sponsors and they work in the same occupation. Those care workers, senior care workers who wish to switch to another employer, they can only now do so if that employer is registered with the Care Quality Commission. On top of all of this, sponsors are also required to provide additional information when they assign a certificate of sponsorship to the new care workers or request a defined certificate of sponsorship. And this additional information is to confirm their CQC registration, or for those sponsors who were previously employing care workers, state in the box that this worker has been employed before, which is why you as a sponsor is exempt from the CQC registration, and also additional information about work location, so where the sponsors are planning to employ these care workers. Okay, and a new restriction on the health and care worker carers, specifically that they are no longer able to bring dependents to the UK. So all care workers and senior care workers already on the route are still able to bring their dependents if they are still employed with the same sponsor and they continue to be employed in their roles and they're not changing to a different occupation. Unfortunately, care workers who have obtained their permissions after the 11th of March are no longer able to bring their dependents, and this is unlikely to change.
Okay.
Yeah. Sorry, I can see that we have some questions in the Q&A chat box.
Okay.
Elaine is asking, how does this apply to care homes in Wales? So the same rules would apply to the sponsors based in Wales and those who are employing workers in Wales. Some are
CQC registration. You would, the same way you would explain the registration in England, you would explain the equivalent registration with the relevant body in Wales, if that's what you mean. But if we haven't addressed your question, just shoot us an email, Elaine.
yes.
So I think somebody is asking about a specific case for their client, which I'm sorry, we won't be able to answer in this webinar. So we're going to move on. We're short on time. So why don't we move on to the phase out of biometric residence permits, please, Medea.
Cool. So one of the most common questions that we get from our clients is why there is an expiry date of 31st December 2024 on their biometric resident permit cards. And the reason for that is that the Home Office is developing a new centralized digital system. So the plan is to replace all physical documents with an online digital evidence of an immigration status. This, however, doesn't mean that the migrants who have a BRP card with the expiry date on the 31st of December have their permissions expire on the 31st of December, the immigration status will remain unaffected. It is just that those plastic cards will no longer be valid, and everyone will then move on to the online evidence of status, which is also called as e-visa. So the Home Office has been already issuing e-visas from 2018. So for instance, if you have employees or if you are a migrant who holds an EU settlement scheme status, it is very likely that you have an e-visa. The plan is to move everyone to use an online account with UK Visas and Immigration. And the Home Office will be inviting eligible migrants by email. So at the moment, the Home Office has already reached around 30,000 student visa holders. But of course, they will be reaching out to more migrants throughout the year and by the date of the expiry on the 31st of December. The UKVI account, UK Visas and Immigration account, is the same tool that migrants who already have it set up use to create share codes and to prove their right to rent. So that means that a lot of migrants already have access to UK Visas and Immigration. So for instance, if they were applying using an app, UK Immigration ID Check app, it's likely that they already have an account. Again, if they hold a status under the EU settlement scheme, they will also have access to the account. For everyone else, it will be expected that the Home Office will invite them to create the online account shortly. So in the meantime, before the expiry on the 31st of December, the Home Office advises to continue using BRP cards when you are traveling. Once the migrant creates a UKVI account and links their identity document to it, it will be possible to have their permission checked at the border using this digital centralized system. However, while this is still in transition, our suggestion is to continue carrying your ID documents. And if you do have it replaced, if your passport has expired and you obtain a new one, it is best to update the details on your account straight away. And these changes take time, so please continue carrying your old documents if you still have access to it. Otherwise, you might be delayed crossing the border.
Yeah, and I just want to emphasize it's very important to update your UKVI account with new passport information if you get a new passport, etc., because that is what is linked to your e-visa.
Yes. And finally, what it means for employers currently sponsoring migrants who do hold a BRP card is that please try to make your workers aware of this potential change. The expiry date on the BRP card still causes a lot of confusion. So if your workers do need that reassurance, please let them know in advance. And there will be also new procedures to verify right to work once everyone has switched to the new digitalized system. We are very happy to assist you with this. So do let us know if you require some assistance with updating the guidelines and procedures to check in the right to work. We have templates and we can issue some notes of advice if that is necessary. Another very important point, as I mentioned, is that some workers will already have their e-visas. So if you employ someone who has a settled status or pre-settled status, you can already check their e-visas instead of relying on the BRPs. Now, again, because this whole process is still in transition, everything is changing. We are, of course, dealing with some procedural flaws, some technical issues. So the Home Office occasionally switches the order of the name. So we have clients who unfortunately have their name for their surname and their surname for their name, and there is no process with the Home Office to rectify this mistake. So it does take a lot of correspondence and going back and forth. So if you employ someone who has been in this situation, let us know, because we've already established some kind of method of rectifying the mistakes on the e-visas. Another point is that some migrants will not have BRP cards because, for instance, their immigration permission was already was endorsed in their passport. Like, for example, indefinite leave to remain would in the past be endorsed in passports. We have a client at the moment who has he is in that situation. He received his indefinite leave to remain in 1998. And we are in the process of obtaining a BRP card for them so that they can then switch to e-visa. So if you are or you employ someone with a permission in the passport endorsed, again, there is no easy way to create an account and obtain an e-visa, but do let us know because there are definitely ways that we can help you with.
Yeah, and we can assist with comms to your employees about how to do it. And also just want to highlight, there's no way for somebody to switch to an e-visa now if they only have an endorsement in their passport. It's possible the Home Office will come up with something within the next year or few months, but there's nothing in place at the moment. All right, thank you so much, Medea. We are, well over time. If you need to go, we won't be offended. We're going to keep going and we'll share the recording. I'm going to discuss right to work changes now, and we'll try to pick up the pace a bit so that we can get through it without taking up too much of your time. So first of all, in terms of prevention of illegal working changes and right to work changes, the civil penalties have increased from 15,000 to 45,000 per instance of illegal working for an initial breach, or for repeat breaches, the penalty has gone up from 20,000 to 60,000. So, these would always add up quite quickly, even more so now with the higher penalty levels. Another point to note is that the 28-day grace period for EEA nationals and their family members has been abolished. What does this mean? Okay, so you might be aware of Brexit, because of which EU nationals living in the UK before 31st of April, 31st of December 2020 had to register with the EU settlement scheme. And there has been an allowance in place for employers because they were not required to go back and check EEA nationals have the appropriate immigration permission in the UK after Brexit. They weren't required to go back and check, but there was a provision in the employer's right to work checking guidance saying that if you do check and you find that somebody doesn't have the status that they require, the immigration permission that they require, and they're an EEA national or a family member of an EEA national, they had 28 days. They had a grace period of 28 days in that situation to allow the employer to tell the employee to make an application to the EU settlement scheme, and then the employee would get within that time frame what's called a certificate of application, the employer could use that to check the right to work according to the Home Office requirements. So that is no longer the case if you do check an EEA national or their family member, even if you employed them before the deadline to apply for the EU settlement scheme, which was 30th of June 2021, and you find that they don't have the appropriate immigration status, then you would have to treat them as you would any other non-UK national who doesn't have the right to work. And so that means initiating termination procedures. Now, I do want to emphasize that you have to go through all of the normal processes for termination that you otherwise would. Don't make a knee-jerk reaction and just terminate them on the spot, okay? Because you'll open yourself up to other claims. So it's a bit of a dance to satisfy all UK laws, because the Home Office doesn't really care what the other laws are. But there you go. So there's also a change in terms of supplementary employment. So sponsored workers are allowed to take what's called supplementary employment, which means to work for an employer other than their sponsor. Now, skilled workers can now take supplementary employment in any role that's eligible for the skilled worker route. There were more restrictions previously. So what does this mean for an employer who's going to be sponsoring somebody, an employer who's going to be offering a skilled worker supplementary employment in addition to their sponsored work? You have to check that the worker can do the supplementary employment in question. So that means you're going to need some evidence to confirm that they're still working for their current sponsor and to confirm their working hours, because it's a requirement that they still be working for their current sponsor, and they're only allowed to undertake supplementary employment outside of their normal working hours. Now, an employer who's offering supplementary employment to skilled workers should also ask the worker if they're doing supplementary employment with other employers. Now, why? I'm going to use the poll again. Supplementary employment. Right. Can you guys see this question? Yes. Why should an employer ask a sponsored worker if they're doing supplementary employment with other employers? All right. This is a free text answer. Why do you need to ask that? There's one restriction I haven't told you about. I'm being a bit mean. There's one restriction to supplementary employment I haven't told you about. Do you know what it is? Because that is the key to this question. All right. Anybody, any ideas? Any more ideas before I end the poll? Why do you have to ask a worker? If you're an employer, a skilled worker comes to you, it says, I'm sponsored by another employer, but I have an allowance to do supplementary employment. Can I work with you? Why do you have to ask if they're doing supplementary employment with other employers? All right, I'll just give a few seconds to let other people answer. All right, I'm ending the poll now. Got 5 answers. Let's see some of these details of the answers. I'm going to share. Oh, I'm not going to share the results, actually, just in case people aren't comfortable. But we have some answers, some saying it might cause an issue with pay and IP. That's possible, but it's not the answer I'm looking for. Oh, we do have the correct answer, and that is that it's the limit is 20 hours. And a couple of people have answered that way. Well done. It's not because it has to be in the same SOC anymore. It doesn't have to be in the same SOC anymore for skilled workers. Somebody offered that answer, and somebody offered that has to be compliant with their weekly hours of work. It does. We've addressed that with the employer's letter. So the answer is there's a 20-hour limit on supplementary employment. So you need to know if they're doing supplementary employment with other employers, so as not to exceed that 20-hour limit. Okay, well done. All right, now moving on. You're being very patient, thank you. Let's talk about changes to the business visitor rules. Two main changes. One has to do with remote working and the other one has to do with intra-company visitors who are undertaking business activities. So in terms of remote working, hallelujah, the Home Office has joined the 21st century and conceded that when people come to the UK on holiday, they might still be responding to emails, answering phone calls, or participating in remote meetings that relate to their work overseas. Okay, fine. But keep in mind that working remotely from the UK must not be the primary must not be the primary purpose of a visit. So how is the Home Office going to assess whether work is the primary purpose? You're going to look at the proposed length of stay. Excuse me. The stay has to be viable financially without relying on the income from the remote working. So the longer the stay is, the less likely that the Home Office is going to accept that work is not the primary purpose. Okay? Hope that makes sense. In terms of intra-corporate activities, so where you have an international corporate group with companies linked by common ownership or control, under the previous and current rules, you can have colleagues from overseas coming to the UK, and with other colleagues, they can advise and consult, troubleshoot, they can provide certain training within compliant with certain restrictions, and share skills and knowledge with colleagues. Now, the change is that they can also do those activities with a client in the UK directly. So the overseas employee can interact with the UK clients, but there are some restrictions, okay? And I've put them in bold here. First of all, the business activity has to be in relation to a specific project. That project has to be being delivered by the UK entity, okay? So the overseas employee cannot be coming to the UK to service a contract between the overseas company and the UK client, okay? The contract has to be between the UK entity and the UK client if you're going to have the overseas employees interacting with the UK clients, okay? The activity has to be of a short duration, and this isn't defined to caseworkers who are assessing these types of activities, but I would normally put it at 1 month. They would expect this type of activity to last no longer than 1 month, maybe up to 3 months with certain justifications, you know, with a good explanation, but you're pushing it there, and the Home Office will want to know that the worker isn't filling a role that should be sponsored, for example, under one of the global business mobility routes, and is not, and is, you know, still required to do their role overseas, okay? Work with clients must not be the primary purpose of an overseas intra-corporate employee's visit to the UK. Now, I'm very quickly going to discuss some changes to other UK work and business visas, and then some of the other UK work and business visas that are options in the alternative to skilled worker sponsorship. So the senior specialist worker, previously known as intracompany transfer, general salary threshold has gone up to 48,500. Same for UK expansion worker. The scale-up route, which I'll discuss in a moment, the general salary threshold is 36,300, and for the graduate trainee route, it's 25,410. Now let's talk about the scale up route a little bit, because I think that this is an underused route, which really could be quite useful. Now that, the home office is just steadily increasing compliance activity, increasing the number of revocations every year. So in 2022, there were 273 sponsor license revocations. And in 2023, it was 337. So I'm not great at maths, but I think that's an increase of about 25%. And so if that's going to continue year on year, and the home office will be relying on these new provisions, allowing for sponsor license action or action against sponsor license, maybe employers would be interested in the scale up route, where you're only responsible for fulfilling sponsorship duties for 6 months. After the 6 months, the worker is then automatically authorized to work for any employer in the UK for the remainder of their immigration permission. There are 2 pathways to apply for a scale-up sponsor license. One is the standard pathway, requires a certain amount of growth and at least 10 employees at the start of a 3-year period before the date of application. There's also the endorsing body pathway. You have to have 10 employees at the time of application, an HMRC footprint, and you have to have potential growth consistent with the home office definition of a scale up. So that means within the next 3 years, would you have that amount of growth? Are you on track for that? And then there are additional criteria that you have to meet, and you have options between those additional criteria. So for example, a Innovate UK award. So the scale-up worker is granted permission for 2 years, but the sponsor is only responsible for sponsor duties for the first 6 months. An extension is available for 3 years, and they might be eligible for settlement after 5 years. And then I just want to highlight another potential route for people, the global talent route. It's available for people in tech, the arts, and academia. First, you apply to the relevant UK industry body for endorsement, and then you use that endorsement to apply for your global talent immigration permission. You can apply for up to 5 years permission. And these are a bit like gold dust, because there are very few restrictions on what type of work the applicants can do. They can work for any employer. They can be self-employed. And the requirements at settlement are quite are relatively easy to meet relative to other routes like Innovator Founder. So Innovator Founder is for entrepreneurs who want to establish and run a business in the UK. Funding is no longer required for this. Previously, a certain amount of funding was required, but you do need endorsement from one of now 3 approved endorsing bodies, and then you use that endorsement to apply for the permission. So the business plan has to be innovative, viable, and scalable. You're given permission for 3 years, and you might be eligible for settlement after only 3 years, but the business criteria at the settlement stage for Innovator Founder are quite complex. All right, let's quickly talk about electronic travel authorizations. And if you could just run through that fairly quickly, because we're now just so over time. Sorry to cut you short, but there you have it.
That's okay. Okay, so the electronic travel authorization, also known as the ETA, is basically a pre-travel authorization that is required by specified nationals in advance of their travel to the UK. I'll mention the specified nationals later, but by the end of 2024, people who do not need a visa to enter the UK will need to have ETA before they travel, and this is to collect information in advance on people coming to the UK and also prevent the arrival of people who present as a threat. Okay, so Jill, somewhat we can't see these slides.
Okay. Can you see that now?
Yeah, could you go to the next slide, please?
Yeah, sorry.
Okay. So travelers who are affected by the ETA are non-visa nationals coming to the UK as visitors for up to 6 months, and the same permissions and restrictions as standard visitors would apply. Some business activities are permitted, and they include negotiating deals and signing contracts. We should all note that paid work is prohibited unless you've got some exceptions.
Okay.
Next slide, please. There are also other travelers that are affected by the ETA, and they include creative workers. So previously, there was allowance for creative workers who were non-visa nationals and were assigned a course for 3 months. Such workers could present their course at the immigration border and get worker permission at the border. But now, they would need to make ETA application before they travel. So the allowance is no longer applicable.
So just to clarify, it will only be as certain nationalities are added to those who are subject to the ETA. So eventually, all non-visa nationals will be added. But at the moment, it's just those certain countries. Over the course of this year, all non-visa nationals will be added. So it's not that everybody has to apply now necessarily, but as soon as their nationality is added, then they will have to apply, including US and EU nationals. Sorry to interrupt, Anna.
That's okay. Thank you for that. Yeah, so creative workers like actors, musicians might be used to not applying for permissions, but now they would need to apply before they travel to the UK. So this should be noted by sponsors of such creative workers. Okay, so let's go to the next slide, Samar, for rollout scheme. So as Samar mentioned earlier, the scheme is open for specified nationals now, and they include Qatar, Bahrain, Kuwait, Oman, United Arab Emirates, Saudi Arabia, and Jordan. But the UK will eventually roll out or launch the ETA requirement to all non-visa nationals, including the US and the EU nationals and their children. So application process would be done via the gov.uk website or the UK ETA app, and you will need your email address, digital photo, payment of £10. Application form would also include your passport details, biographic data, contact details, and suitability questions such as criminal conduct questions or previous breach of immigration laws. So when it comes to refusal, some grounds for refusal of ETA application include where an applicant's identity is not verifiable and where there's like criminality, bad character or conduct, when there's like breach of immigration laws, breach of visa conditions, where you've got debt to the UK National Health Service or any unpaid litigation costs owing to the Home Office, and also where there's deception used in relation to an immigration application that was made previously, whether or not it was successful. So there's also no right of appeal or administrative review for refusal of ETA applications. Thank you.
Thanks so much, Anna. That's super useful. And just to give some insight into these processes, ETA approvals can be made via automated processes by the Home Office. The automated processes might flag an application for refusal. The refusal would then be issued by a caseworker. It would be reviewed by a human, and if they want to proceed with the refusal, they would have to, a human would have to authorize the refusal. And there is no, the Home Office is allowed to afford no admin review or appeal rights, because that's only required for decisions made via automated processes. Just an interesting point there for all you immigration nerds out there. We've gotten through a huge amount. I'm so sorry that, you know, it's taken us quite some time to get through it all. I appreciate that people had their hands up and we didn't get to those questions. If you are an immigration provider and you've been asking questions, just to let you know, we're not going to answer those questions for you. We're just simply not able to provide that kind of service to other providers. But check out the Immigration Law Practitioners Association training and resources. I would recommend that. If you are an employer and you have questions, please do contact us directly. If we didn't get to them here, we'd be very pleased to answer those questions. And I'm now going to end the session just to release everybody. But as I said, do be in touch if you need any help. Thank you so much, Medea and Anna. Really appreciated your input today. It was fantastic. And thank you all delegates.
Thank you. Bye.